Next week to. Ini kan langsung foreign law adjourn, kalau diam dia kalau mau sini tu lah. Bukan sini gini kan langsung ada kalau không选什么么，我们现在听不懂当地人话，就给你个证，经济什么的，马上他那个这些了，把你看，这个。那设备也不知道。我这个民国两几个人。很多人，我跟我们说嘛，我们那是。
Yes.
Your Lordship, may I make a mention regarding hearing list item 9? It's a joint prayer, Your Lordship. It may be taken up after a week, my Lord. This is RFA.
Yes. Okay. What about both the councils are present?
Yes, Your Lordship. I'm for the appellant.
Okay. On the submission made by the learned councils for both the parties, list after 1 week.
Much obliged, ma'am.
Seek Your Lordship indulgence, Your Lordship, item number 11 of part 2. It's a joint prayer, Lordship. It may be taken up next week.
On the submission made by the same, okay? List in the next week.
Deeply obliged.
Lordship, item number 7, part 2. It may be taken up after a week, Lordship.
What happened? You all are not prepared.
Lordship, actually that senior counsel, Mr. L.H. Lenshima, is not available.
Okay. On the submission made by the learned counsel for the appellant, Mr. Johnny L. Tochung, learned counsel for the appellant, okay, has prayed for adjournment of the matter. In view of the above list,
After a week, Lordship.
after 1 week.
If it please Your Lordship, I would like to mention for part 2 item number 3.
Treats fixed for hearing today.
Yes, my Lord.
What happened?
Due to personal difficulties of my senior, as he's having fever and cough right now,
Who is your senior?
Mr. F. Lengliana. That is for the respondent.
Mention is made on behalf of Mr. F. Lal Engliana, learned amicus curiae, for adjournment of the matter, since the learned amicus curiae is not able to appear due to some personal problems. Some personal problem.
Much
In
obliged.
view of the above list,
Any
after
available
1 week.
After 1 week. Much obliged.
Part 1 list, motion, item 1.
Your Lordship,
Yes.
this is an application claiming relief and rehabilitation under the Right to Fair Compensation Act of 2013. There's a provision under Section 16 of the Act for making assessment and compensation. Lordship, to be paid to those landowners.
16. Oh,
16.
oh. Yes,
May I read, Your Lordship?
yes, please go ahead.
Preparation of rehabilitation and resettlement scheme by the administrator. Upon publication of the preliminary notification under subsection 1 of section 11 by the collector, administrator for rehabilitation and resettlement shall conduct a survey and undertake a census of the affected families in such manner and within such time as may be prescribed, which shall include particulars of land and immovable properties being acquired of its affected family. B, livelihoods lost in respect of land losers and landless whose livelihoods are primarily dependent on the lands being acquired. C, a list of public utilities and government buildings which are affected or likely to be affected, where resettlement of affected families is involved. D, details of the amenities and infrastructural facilities which are affected or likely to be affected, where resettlement of affected families is involved. And E, details of any common property resources being acquired. Subclause 2, the administrator shall, based on the survey and census under subsection 1, prepare a draft rehabilitation and resettlement scheme as prescribed, which shall include particulars of the rehabilitation and resettlement, entitlements of each land owners and landless whose livelihoods are primarily dependent on the lands being acquired, and where resettlement of affected families is involved. 1, a list of government buildings to be provided in the revenue resettlement area. 2, details of public amenities and infrastructural facilities which are to be provided in the resettlement area. And also here, the petitioners, some of them are the landowners, some of them are the tenants of those landowners. They have been affected, and as a result of the widening of the road, that National Highway 54, they are required to be dislocated, and they are to be shifted to certain areas to land to be provided to those landless persons. But because of the absence of lands, they are to be given compensation in lieu of land as a matter of rehabilitation and resettlement under that scheme. And in spite of the fact that the assessment was made under the 2013 Act, the central government had made certain objections, stating that the scheme, the project under which this road construction has been made is under the ZICA scheme. So it has to be assessed under the ZICA scheme only. And because of that, the assessment which was made under the 2013 Act was not approved by the central government ministry. It was sent back, and thereafter a fresh assessment was made under the ZICA scheme. Lordship, at page 61, Lordship will see Annexure 10. It is a letter addressed by the Deputy Commissioner Sesip District to Executive Engineer, NHIDCL, on the subject of submission of rehabilitation and resettlement award as per ZICA guidelines, entitlement matrix in connection with NH54, widening and upgradation, Aizol Tuipang, within Sesip District. So under this, the assessment was made and it was so much reduced. We are not much concerned with the amount as we are concerned with the authority under which, or the law under which this assessment is to be made. Lordship, the humble prayer of the petitioners is that since the law is well settled, that for acquisition of land and dislocation of those persons in connection with the acquisition of land, resettlement, relief and resettlement, rehabilitation is to be made under the 2013 Act only. But because of the wrongful intervention of the government of India, on the ground that it has to be done in accordance with the desires of the funding agency, that is ZICA, Japan.
Okay.
So Lordship,
Will
pray-
issue notice? Isn't it? Will issue notice?
yes,
So you're saying that steps were initially taken under section 16?
yes,
of
under
the
16,
Act.
yes.
And assessment was made?
Assessment was made in respect of those affected persons.
Okay, under section
It was
16.
submitted, yes, it was submitted to the
Okay.
government of India and it was returned unapproved.
Okay, fine. Heard Mr. Sila Ramzawa, learned senior counsel for the petitioners, okay, assisted by Mr. So-and-so. Yes, learned counsel. Full stop. This is an application filed under Article 226 of the Constitution of India for issuance of the appropriate writ to the respondents on the grounds that the lands of the petitioners were earlier acquired for the purpose of construction of two-lane national highway from Aizawl to Tuipang of NH-54 within the state of Mizoram, as a result of which the petitioners were dislocated from their lands located on the side of the said national highway. Full stop. Initially, an assessment was made under section 16 within brackets 1 of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act, 2013 within brackets hereafter referred as 2013 act, draft rehabilitation and resettlement assessment was accordingly made in respect of the land of the petitioners. Thereafter, the state was sent to the respondents number. Central government is respondents
5 to
number
8, Your Lordship.
5 to 8. However, the said draft assessment was not approved by respondents number 5 to 8 and was sent back on the grounds that the rehabilitation and settlement assistance is to the petitioners is to be made under the JICA guidelines and not under the 2013 Act. Accordingly, steps were taken and assessment made under the JICA guidelines, wherein the amount of compensation / rehabilitation was much less than what is entitled to the petitioners. Aggrieved, the petitioners have filed the instant writ petition. Issue notice of motion to the respondents. Ms. So-and-so, learned government advocate, accepts notice on behalf of state respondents number 1 and 2, while Ms. Zairam Sangpui, learned CGC, accepts notice on behalf of respondent number 5. It must be 4 and 5. Is it central government?
No, not 4. 5.
Okay. Respondent
Lordship,
number.
this National Highway NHIDCL and all the officials under them, we may have to take steps in respect of those.
Yes, what about Mr. Samuel? 6 to 8, Mr. Samuel, so-and-so. You are appearing as? Okay, standing counsel for NHIDC accepts notice for respondents number
6, 7, and 8.
to 8. Notice is to be issued to respondent number 5, is it?
3 and 4.
3 and 4 through registered post with AD within a week, returnable by 3 weeks. List after 3 weeks.
Okay.
Item 2.
Yes,
May I please, Your Lordship? This petition is filed challenging the advertisement issued for the 20 posts of ASI ministerial under the Home Department, which was issued on 4th July 2024. Even though the petitioner is a candidate, he has filed his application for the post of ASI. But we have challenged this advertisement because it does not mention the 5% reservation, which should be kept for the meritorious sports person. I'm a black belt in Taekwondo. I have represented India in the international level and the state of Mizoram in the national level. Already, if I may take your lordship to the office memorandum, which was issued by the respondent number 2, page 35. Now, at clause 2, the definition of meritorious sports person is defined. Clause 2(1), subclause A, sports person domiciled in the state of Mizoram who have represented the country in international competitions in any of the games sports mentioned in this instruction. Your lordship will see that at page 39, clause 9, the name of the sports is mentioned, wherein at serial number 24, Taekwondo is mentioned at serial number 24.
Page 39.
Page 39,
Uh,
clause 9, serial number 24 of the table.
Now, in the copy that I have, okay, Taekwondo.
Yes,
Okay,
your lordship will
yes,
see
yes,
the
yes,
table.
yes.
Now, this advertisement issued by the MPSC does not mention that 5% reservation has to be.
Okay, where's
Even.
the 5% reservation mentioned?
Now, at page 36,
36.
36 at clause 3,
Oh,
subclause 1. 5% of the vacancies in Group B, Group C, and D posts falling with the direct recruitment quota as per the recruitment rules can be reserved for being filled by meritorious sports persons. Now,
it says can be,
yes,
not
that's
shall
correct.
be.
That's correct. Now, I have submitted my representation to the respondents 1 to 4 on 13/8/2024, wherein I have stated this OM and the rules which govern for the recruitment of this ASI. Now, my representation has
Where's
not
your representation? Okay, page
45.
45, yes.
My representation has not been considered till date. I have mentioned this OM in the recruitment rules. My lord, if I may mention that this OM has been issued by the respondent number 2 and the object sought to be achieved by issuance of this office memorandum is for promotion of sports. Now, unless this OM has been effectively implemented, no person will take up sports as a career unless this is effectively implemented. So my main prayer is that the advertisement which was issued by the MPSC for filling of 20 posts without mentioning the reservation, 5% reservation for meritorious sport person should be set aside and cancelled, and a fresh advertisement has to be issued incorporating this OM, clause 3.
But the OM which you just read, one thing that struck me was that it is not shall, it is can be.
Yes, that's
So
correct.
when the word can be is used, it is not necessary that it has to be 5%. It
that-
can be. It
That
depends.
is correct.
that
I agree
word
with your
can,
lordship. I agree with your lordship, but the object sought to be achieved by this office memorandum is for promotion of sports. Now, unless this is effectively implemented, no person will take up sports as a career, and those person who has taken up sports will have no chance to be taken as a government servant, because they have to compete with those persons who has not taken up sports. Now, at this stage, if your lordship may allow me to produce a judgment of the
Yes,
Arunachal bench.
yes.
Now, in WPC 44 of 2014, the issue was with regard to non-reservation of 5% for the post of Panchayat Technical Assistant under Panchayati Raj Department. Now, in this case, the government of Arunachal Pradesh has issued an office memorandum, which your lordship will see at page 3 of the judgment, dated 14/5/2001. Now, by the said office memorandum, this authority of the state clarified that all the appointing authorities, head of the Department of the State, clarified that recruitment not more than 5% of the vacancies in Group B, C, and D posts against direct recruitment amongst meritorious sport person belonging to APST in relaxation the recruitment procedure under the conditions as stipulated in the office memorandums, as the government of India noted above. Now,
Here there appeared to be a memorandum, office
Yes.
memorandum, which was issued by the government of India.
yes,
Have you got hold of that?
the government of India memorandum is with regard to recruitment to Group C and D.
Okay. For
Now-
sports person.
Yes,
isn't
sports
it?
person.
So this is something slightly different anyways, huh? Please
Now,
go ahead.
here in this case, in this Arunachal case, it is with regard to Group B, C, and D posts. Now, at page 5, I'll just read para 13 and 14.
Yes.
Persons who take sports as their career devote much of their time in preparing themselves for the concerned events, and for the same, naturally, they cannot give sufficient time for their studies, and for that, they cannot focus on their educational career. As such, they may not be in a position to compete with the other students who prepare themselves for such educational career. After participating in various sports competitions at international or national level, and on completion of their certain competing age in the sports, these meritorious sports persons look for service as an avenue for their living. Para 14. In order to promote sports in the state and also to take care of such meritorious APST sports persons, the state of Arunachal Pradesh have taken a policy decision to reserve 5% of posts in jobs in Groups B, C, and D posts for them, in relaxation of the recruitment procedure in the same terms and conditions as notified by the government of India in their office memorandum issued for the said purpose. In that regard, the state government, through the Department of Personal Administrative Reforms and Training, have issued the office memorandum dated 14 May 2001, informing all the appointing authorities and head of departments of the state to comply with the same. Therefore, this reservation of 5% of posts in jobs in Group B, C, and D posts for meritorious sports persons who fulfill the eligibility criteria laid down in the said OM, as well as the relevant OM of the Government of India specified in the OM dated 14/5/2001, shall be applicable in all the offices of the state of Arunachal Pradesh, and also the cooperation undertaking, local self-bodies, and other institutions that receive benefits directly or indirectly from the state and central government. Moreover, said policy decision is not under challenge, and the same is enforced in the state. Paragraph 15. Policy decision of the state government dated 14/5/2001 have already been considered and upheld by this court in other proceedings, and the benefit of said OM dated 14/5/2001 has already been given effect to by other agencies of the state like SSA, Arunachal Pradesh. At para 16, considering all these, the respondents in the Panchayati Raj Department of the state of Arunachal Pradesh is directed to fill up 5% of posts of Panchayati Technical Assistant out of 177 posts as per the advertisement made on 21/1/2014. On such 5% of posts that are kept vacant by the order dated 5/2/2014 passed earlier, in the case from amongst the meritorious Arunachal Pradesh scheduled tribe sport person as per the policy decision of the state in its office memorandum dated 14 May 2001 following the direction given in the said OM. Now, as per this order, my lord,
See, this is concerning a different OM.
yes,
Now, if
your
you come to
OM,
page 36, my only concern is if you come to page 36
yes,
of your petition,
yes,
and if you look at the OM para 3, subpara 3,
yes.
okay, just read that.
Yes, correct. Reservation is not to be construed as legally mandatory in nature, but the same may be considered to the extent as prescribed in subpara 1 by the respective appointing authorities. Reservation of vacancies for persons with
See, is not to be construed as legally mandatory
Yes,
in
correct.
nature. That's
Correct.
what.
Now, if we look at the last three
Yes,
lines,
yes.
however, reservation as prescribed at subpara 1 above should be given due preference by the appointing authorities when there are eligible candidates fulfilling the eligibility conditions as prescribed in the instructions and the relevant recruitment rules. Now here, the advertisement does not mention that due preference will be given by the appointing authorities. That is why we have challenged this advertisement 4th July 2024.
Anyways, we'll issue notice first. Let's see.
Now, my lord,
Let's look at the advertisement.
Yes.
Advertisement is at page
advertisement is page 25.
25. Okay. Now, when is the last date? Any date mentioned?
Now, the physical measurement will be held on 26 to 28,
Of this month.
the next Monday.
Okay, from Monday.
Now, we have an intent prayer. If I may just place this copy.
This was issued way back in 4th July.
I have submitted my application on 12 July 2024. If I may just apprise your lordship of the rules governing the recruitment of Mizoram Home Police Department, Group B non-gazetted post, that is the present case. Page 32.
Yes.
Clause 9, Rule 9, sorry. Nothing in these rules shall affect reservation, relaxation of age limit, and other concessions required to be provided for the scheduled caste, the scheduled tribe, the ex-servicemen, and other special categories of persons in accordance with the order issued by the government of Mizoram from time to time in this regard. Now, why I'm reading this is that this advertisement, which was issued by the MPSC, did not incorporate this relaxation and the OM clause 3, subclause 3, which I have submitted before your lordship. So that is why we challenge this advertisement, and we sought the intervention of this court to issue a direction to the respondent authorities to issue a fresh advertisement incorporating all this OM issued by the respondent number 2 and the rules governing the recruitment of ASI ministerial under the Home Police Department. And my interim prayer is that Any further steps or action that may be taken by the respondents in pursuance of the advertisement issued on 4th July 2024 by the MPSC may be stayed until disposal of this writ petition, madam. That is my humble prayer.
I don't think it would be very appropriate to stay everything, since now steps have been taken, preparation has been made, isn't it?
Yes.
So, but the advertisement will be subject to the outcome of this writ petition. We can make it that reservation, that can be added at any
Yes.
time,
Yes.
isn't it?
Madam.
But simply staying when all the steps have been taken and the actual physical measurement is to take place, as you say, on Monday, it would be causing a lot of inconvenience. People could be coming from outside the state to participate. Yes.
So our
We'll
main
issue
our main
notice.
concern is that one person post
Yes,
one post.
so, yes, that will be subject to the outcome of this writ petition,
Madam.
isn't it? Yes. Heard Mr. C. Lal Pagzwala, Learned Counsel for the petitioner. Full stop. The instant petition filed under Article 226 of the Constitution of India is for the issuance of the appropriate writ or order to the respondents number 1 to 4 with regards to the advertisement within brackets Group B non-gazetted post close bracket number 4 of 2024-2025 issued by the respondent number 4 provide the notification dated 4th July 2024 and for a direction to the respondents to publish a fresh advertisement providing for 5% reservation within brackets 1 post close bracket for meritorious sports person out of the 20 numbers of post for assistant sub-inspector of police within brackets ministerial close bracket under the within brackets police department comma government of Mizoram in terms of the office memorandum dated 14th November, 2019 and Rule 9 of the Mizoram within brackets Police Department within brackets Group B non-gazetted post close bracket Recruitment Rules 2023. Now, you have not led me to this recruitment rules.
I have just mentioned that.
The one which you mentioned, Rule 9.
Yes.
Okay, that's special reservations to
Yes,
be made.
yes.
Okay, yes.
It's at page 31,
Yes,
madam.
yes. The learned counsel for the petitioner submits that the instant petitioner
Page 4 of my writ petition, madam.
yes, is a graduate in Bachelor of Arts within brackets Geography and a Taekwondo athletic who had athlete
Yes.
who had represented India in the international level and the state of Mizoram in the national level. The petitioner has won gold and bronze medals and is therefore entitled is therefore qualified, okay, for direct recruitment to the vacancies reserved for meritorious sports person as mentioned in clause 9 of the office memorandum. Okay, next
There
slide.
would be clause 2, meritorious sports person.
Okay, clause 2. No. In the office memorandum,
Yes, clause
it's
2.
clause 2
Yes.
instead
And-
of 9.
9 is the name of the sports mentioned.
Okay, clause 2 of the office memorandum. Notice be issued to the respondents, Ms. so-and-so, learned government advocate, accepts notice on behalf of respondents number
1, 2, and 3, Your Lordship.
1 to 3. And Mr.
But I am appearing on behalf of my senior land counsel for the respondent number 4.
Okay, and Mr. So-and-so accepts notice on behalf of his senior, Mr.
Jesse Lunsanga.
or J.C. Lalnunsanga, standing counsel for,
MPSC respondent
MP.
number 4.
okay, MPSC, respondent number 4. Anyone else?
No.
Okay. No need to issue a formal notice. Requisite copies of the petition to be duly furnished to the respondents. The learned counsel for the petitioner has also prayed that the operation of the instant impugned advertisement dated so-and-so may be stayed till the disposal of the instant writ petition. This court, however, finds that since steps have been taken and steps have been taken in pursuant of the advertisement wherein physical test is to be held on
Yes,
Monday
ma'am.
is what?
26 to 28.
26 to 28 August 2024. It would not be appropriate at this stage to stay the operation of the said advertisement. However, the advertisement with regards to reservation, with regards to 5% reservation for a sports person, will be subject to the outcome of the instant writ petition. Yes, list after 3 weeks.
Madam. Obliged.
Admission, item 3.
Yes,
May I please, Your Lordship? Lordship, I'm on behalf of the senior counsel for the respondent number 9. Lordship, with regards to the matters, we have almost finished our affidavit. However, the signature of the respondent 9 is still not. Is still
okay, so
missing.
you need further time, isn't it? Yes.
Yes, Lordship.
Miss
Narintari.
Lalrin Thari, learned counsel for respondent number 9, submits that she may be given a further 2 weeks' time.
1 week.
Okay, further 1 week's time to file their show cause reply, which is at its final stage. Accordingly, list after 1 week.
Item 4.
Lordship, may I please, Your Lordship, pleadings are completed if the matter can be listed for admission hearing after a week.
Who is the counsel for the respondents? Okay, so pleadings are complete.
Yes, ma'am.
Ms.
Laropari.
Lalropari, learned counsel for the petitioner, is present along with Mr. Samuel L. Sankte, learned additional AG for the state respondents. Both the counsels submit that pleadings are complete and the matter can be listed for admission hearing. Accordingly, list this matter for admission hearing after 2 weeks.
Item 5.
Yes,
My lord, as far as my instruction goes,
counter affidavit, government.
yes, my lord.
We have to wait for your counter affidavit. That's the last order.
If your lordship will allow us 2 more weeks' time, my lord.
Mr. Samuel L. Thanke, learned additional AG, appearing for the state respondents, has prayed for further time for filing of their counter affidavit. Accordingly, list after 2 weeks. Yes.
Obliged.
Item 6.
My lord, we are for the respondent number 2, and we have sent Wakalatnama to the respondent number 2, but we haven't received it back, so we'll need another 1 week time.
Okay, Mr. Murmu, learned counsel for respondent number 2,
Yes, my lord.
has prayed for a further time to file their counter affidavit. In view of the above, list after.
Power, my lord.
Oh, power.
Yes.
Submits that they will be appearing, instead of counter affidavit, okay, appearing on behalf of respondent number 2, and will be filing their power within
1 week.
1 week. In view of the above, list after 1 week.
My lord, may the interim order be continued.
Meanwhile, the interim order passed earlier shall continue till the next returnable date. We'll mention your appearance.
Yes, my lord.
Miss
Vanna Sonia.
Vanal Somi, learned counsel for the petitioner, is present. Okay. Along with Miss
Miss Lennon Louis for respondent number 1.
Miss So-and-so,
1 and
learned
4, Your
government advocate for respondent number
1 and 4, Your lordship.
1 and 4. Okay, are present.
Item 7.
Yes.
May please, Your Lordship. My Lord, as allowed by this honorable court, we have taken steps upon the respondents by way of dusty, and we have also submitted our affidavit of service.
Let's see the affidavit.
It was submitted
Duly
on the
signed?
My Lord,
Okay, it is signed by the
the respective
executive
respondents.
secretary.
My Lord.
Heard Mr. Dalfakoma, learned counsel for the petitioner, who submits that notice has been duly served to the respondents and affidavit to the effect has been filed. On perusal of the affidavit, it is seen that notice is served to the respondents. However, none appeared for the respondents. In view of the above, list this matter after 2 weeks.
Obliged, Your Lordship.
For order, item 8.
This is an appeal from jail, and PP not present. Now, Mr. J.C. Hunsanga has been appointed as an amicus curiae, but I don't think he'll be able to appear, isn't it?
Your lordship can appoint some other counsel.
I think we can appoint some other counsel. Okay, okay. Yes, yes. Now, in this matter, it is seen that there was a previous jail appeal, which is still pending before this court. And then the appellant had made a second application. So in view of the above, we will dispose of this instant appeal. This matter has been put up today for consideration, since the office note, there should be office note, reflects that the same judgment and order dated 29/09/2021 passed by the Fast Track Court within brackets Rape and POCSO Act close bracket Champai in FTSC within brackets PCI close bracket POCSO 15/2021 arising out of SC number 174/2017 in criminal trial number 1397/2017 under section 10 of POCSO Act, wherein the accused was sentenced to undergo RI for 5 years and pay a fine of rupees 1,000 with default clause, is also pending before this court in criminal appeal number 1 of 2022 within brackets J. It is seen that it appears that the appellant has filed the appeal application before the disposal of the said criminal appeal number 1 of 2022 within brackets J. In view of the above, the instant criminal appeal number 28/2024 is dismissed since the same is pending before this court in criminal appeal number 1 of 2022. Yes.
Item 9.
Yes, what is the stage?
My lord, we have filed our power for respondent 1, 3, 4, and 5.
So what is the IA about?
It's for to stay the operation of the impugned judgment, my lord.
Yes.
I'm the plaintiff in the trial court, and I have filed eviction suit against the respondent defendants, and they have filed counterclaim. And while dismissing the suit, the learned trial court had allowed the counterclaim. And the direction of the learned trial court is to cancel the LSC mutated into my name in favor of mother-in-law of the appellant number 1, who is not even a party to the suit and already expired.
Mother-in-law
Of the appellant number 1.
you are the appellant.
And sorry, respondent number 1.
Okay.
I'm the plaintiff appellant.
Okay, appellant.
The suit property is in my name, LSC is in my name. And the decision of the land trial court is to cancel mutation of LSC in my name and mutated the same into the name of mother-in-law of the respondent number 1, who was already expired and not even a party to the suit. So
okay, so
we have filed this RFA within time, my lord, and LSC are already arrived.
So what is the IA about? IA is
To
for
stay
what?
the
Okay, stay the okay.
this may be allowed.
Yes, what do you say?
My lord, we'll be filing our counter affidavit for that. And we
Having
haven't received
the-
the copies.
Having
yet.
the appeal filed within time.
Anyways,
it will be hard on my-
so yes, appeal is filed within time, but now you want to stay of the operation of
Yes,
the
my lord.
judgment and order appeal
Otherwise, my lord,
But he
the-
says, so let them file their written objections, we'll see whether there's any reasonable reason as to why they are objecting, isn't it?
The interim.
Since they
may
have
be
already
continued for
prayed.
time.
Yes, in the meantime, we will stay till the next date. Heard Mr. Victor L. Ralte, learned counsel for the applicant, along with Mr. Ram Murmu, learned counsel for learned counsel, who submits that they have filed their part and for respondents number 1 to 5 and has prayed for further time to file their written objection in the instant IA. In view of the above, list after 2 weeks.
Yes, ma'am.
Meanwhile, interim order passed earlier shall continue till the next returnable date.
Can it be 3 weeks, my lord? I have If it
Okay.
turns out after 2 weeks, I have some personal inconvenience.
3 weeks instead of 2 weeks, 3 weeks. Yes.
Deeply obliged.
Okay, no, this thing. Hearing.